The benefits of cash for keys in California before a probate sale. That's our topic today, and we'll get started right after this. Cash for keys in California agreements are a way for executors, administrators, and trustees to offer a tenant or a family member living in the decedent's home a financial incentive to vacate a probate property or a home in a trust administration so that we can move forward with the probate sale or the trust administration sale. We'll be using the term tenant from this point because there may be an actual tenant or there may be a family member without any written rental documentation or even a friend of the decedent. Again, without any formal rental documentation, and in the absolute worst case, squatters. For simplicity's sake, we'll refer to all of them as tenant. Cash for keys in California can be useful in situations where the personal representative wants to reclaim the probate sale property quickly so that it can be prepared, marketed, and sold, and so that the estate can move forward with the rest of the probate sale process with their probate attorney. Hi, I'm KimWard. Welcome back to our channel. I am a certified probate real estate advisor and experienced real estate broker here in San Diego County. My team and I have helped hundreds of executors, administrators, and trustees with homes in probate or a trust administration. Now let's get back to talking about a probate sale and cash for keys in California. In a cash for keys agreement, the personal representative offers the tenant in the decedent's home a cash payment in exchange for agreeing to vacate the probate property within a certain time frame. This can be a win-win solution for both parties, as it allows the estate to reclaim the probate property more quickly while providing the tenant with a cash for keys or financial cushion to help them transition to a new home or a new rental. While cash for keys in California agreements can be a useful tool for personal representatives, it is important to carefully consider the terms of the cash for keys agreement and ensure that it is fair and legal. It is also important to consult with a probate attorney before entering into a cash for keys agreement. Last year I was helping Catherine, and she had a home in Santee, it's a suburb of San Diego, and her sister was living there and didn't want to move out of their mother's home because she didn't have the funds for a first month's rent and a security deposit. And so I talked with Catherine about the option of providing her sister a cash for keys agreement. So she talked with her attorney and they came up with negotiating $5,000 so that the sister then had the funds to go ahead and move out of the mother's home and into another rental. And the other part of that is that $5,000 was also going to be taken out of the sister's proceeds from the sale of the property so that it was fair amongst the sisters, if that makes sense. Let's go a little bit deeper into what is cash for keys in California. And cash for keys is often a pragmatic and cost-effective way of removing tenants from a property. With a cash for keys offer, for example, the executor, administrator, or trustee, by offering a small amount of cash in exchange for vacating the property, may be able to avoid an expensive and very time-consuming eviction, as well as the emotional toll of having to perhaps evict a family member from the home so that the probate sale could be taken care of. As a side note, according to the American Tenant Screening, the average cost of evicting a tenant could easily run several $1,000s in legal fees. On top of that could be extra fees for clean out and storage expenses of the tenant's personal property. So you may be wondering, is cash for keys legal? And the answer is cash for keys in California is absolutely legal. You're going to want to make sure you have the proper documentation that is legally binding between the executor, administrator, or trustee and the person that is living in the decedent's home. And the benefit is that you can avoid going to court. And I mean the eviction court, not probate court. To make sure that the documentation is properly completed, I recommend you get some legal advice, because if something is not accurate on the cash for keys agreement in California, you might have to start all over again when the person does not vacate the home in probate or trust administration. So you want to make sure everything is completed accurately and legally before entering into that cash for keys agreement. So before signing the cash of keys in California agreement, the personal representative should review any lease agreement and understand the landlord's and tenant laws for California. That's because the cash for keys agreement will need to comply with the local laws in order to be enforceable. Another reason to get legal guidance prior to moving forward with a cash for keys agreement. There are several deliberate steps you'll want to take to encourage the person living in the decedent's home to accept the cash for keys agreement. Your legal representation may recommend serving an eviction notice. If that is the case, once the tenant receives the notice, you can then approach the tenant offering to make a deal to help the tenant avoid any eviction. After explaining to the tenant the risks of a potential eviction, meaning a blemish on the tenant's credit report and a negative rental history, you would then offer the cash for keys as a winning solution for both them and the estate. Since you are involved with a probate or trust administration, you may be offering cash for keys for a reason other than eviction. Your biggest leverage in getting them to move out of the property is going to be how much you offer for cash for keys. So think about the maximum amount you'd be willing to pay them. Perhaps start with a lower offer and then negotiate from there. The cash for keys in California documents should be specific, including the amount of the cash offered, the exact date the tenant will vacate, and the condition of the property once they do leave. Of course, you're going to want to use a written cash for keys agreement, and again, you might want to get that from your attorney. You'll then want to have a scheduled signing date after the verbal agreement is made. Probably as quickly as the next day would be the best for meeting the tenant to sign. You want to review the agreement with them and verify the cash payment due, the move out date, and how you expect the property condition to be once they hand over the keys to you. Some people hand over the cash once the cash for keys agreement is signed. I don't recommend that, while others wait until the date of the move out inspection. That, of course, would be you and your attorney's decision. On the date that was agreed upon, at the time that was agreed upon in the cash for keys agreement, a move-out inspection should be conducted in the presence of the person that was living in the property. If the property is left in reasonable condition, it's best to just go forward with the cash for keys agreement payment and then deal with the final cleaning afterwards. You're going to want to change the locks immediately. When I've been involved with a cash for keys agreement, or sometimes an eviction process, I have the locksmiths come to the property 30 minutes after the time that I was to meet with the person living in the property and handing over the funds that was agreed upon in the cash for keys agreement. Changing the locks is a very important step because you don't want to go through the cash for keys agreement and then have the people move back in potentially. Now let's talk about common mistakes in a cash for keys agreement. These are the things that you definitely want to avoid. 1, avoid negotiating with the person living in the property by explaining why the cash offer is what it is. Instead, just stand firm. 2, do not violate the tenant rights by changing the locks or turning off the utilities before they vacate. 3, if there happens to be a security deposit, which in most cases of a probate in California, there isn't, but if there is, keep that security deposit separate from the cash for keys agreement because you're going to want to have those funds available for any damage caused by the tenant beyond normal wear and tear. And as a little side note, you have 21 days from the time the tenant moves out to address the returning of the security deposit or not returning it if there's repairs that need to be made. That's a whole other video. 4, finally, put the cash for keys agreement in writing and have the person living in the property sign in the event the document needs to be used in an actual eviction process. So that's a lot regarding a cash for keys agreement in California, and I hope you found that of value. Please like, subscribe, and comment or ask questions. And thanks for watching, and I'll see you next week.